everybody, and welcome back to the Legal Weekly Wine, where we talk about the week's hottest legal topics. It is the next to last week in January 2024, and the legal topics keep coming. It has been a fairly momentous week, even outside of former President Trump, which we have been talking about a lot. We are going to mention him briefly today with the updates on the E. Jean Carroll case, his very brief testimony and what it might mean. But we're going to focus on some other things this week. We're going to talk about the Eighth Amendment and cruel and unusual punishment with the execution that went forward this week. We are going to talk about Texas and immigration. We hit this topic a couple of weeks ago, but we are coming back to it because after the court issued their decision, Texas is defying that decision and is still laying down barbed wire to prevent incoming potential immigrants, legal or illegal. And there is a fight essentially between state and federal governments. We're going to talk about the law that governs that, especially the Supremacy Clause, and what might happen if the governor continues to reject the decisions of the courts. We are also going to talk about the International Court, and stay tuned for Thomas Hobbes, as well as we got to throw something in there, right? So if you're wondering how Thomas Hobbes fits into all of this, please stay tuned. The other one to stay tuned for in our topics, even if you've got to skip around, is Dr. Weil and I are going to have a hot topic and hot conversation regarding the Michigan parents who have been charged with manslaughter regarding their son who was the school shooter. So we're going to have a really interesting conversation about that and how it applies also to the Newport News shooting. We're going to turn it all around. Join us for this interesting conversation with those topics. I'm Virginia Tehrani. I am with Tehrani Law, LLC, because you never need a lawyer till you do. And I am also the CEO of the Law Unscripted, which hosts this podcast of the Legal Weekly Wine, as well as offering law exam and bar exam review classes. Check us out on thelawunscripted.com for those classes to check us out and also to have access to the podcasts. I am joined by co-host Dr. John Weil, who is the Dean of the Honors College of Middle Tennessee State University. Welcome back.
Glad to be here.
I'm excited about today. I think we are both very passionate about many of the topics today. So it might be even more lively than usual.
It might.
We'll see. Okay, so let's talk about the wine because it is the weekly wine, and then let's get straight into our topics. I know you're not drinking wine, but what kind of water do you have today?
Spring water.
Spring water. Okay. Yeah. Very healthy, much healthier than mine, but grapes are fruit, I assume, and they have some kind of medical quality, allegedly. I am drinking Sauvignon Blanc from the south of France, a 2022 Montgravé is what I am drinking. I do not do many Sauvignon Blancs, so I am very excited about it. Cheers to you, Dr. Weil, and we'll see how well I like this one.
And you must have gotten something from your French major, right? Because you said Gravé instead of Gravette.
Right? I really tried to pronounce it somewhat correctly. The little bit I kept from my French major, however many decades ago. I think it's been at least 25 years now. So yeah, Gravé. Cheers to French. Oh, that's actually very good.
Or is that Spanish?
That's Spanish, I think. Yeah. No, that's very good. That's very light and refreshing, not as dry as I expected, and I don't love the dry wine, so I'm pleased. It's very soft and subtle and delicious, so I will continue drinking that wine today. All right, Dr. Weil, let's start out with, goodness, what do we want to start out with?
Texas.
Let's start out with Texas. Give us an update of what has happened, and then we're going to talk about what's happening this week.
Yeah. And so that people, don't think I have a grudge against Texas. I think we hit them hard last week because of Uvalde.
Yes,
but
we did.
What's happening now actually has much more constitutional significance.
Correct.
Which is essentially the Governor Abbott is defying federal authority over naturalization. And by the way, just so people will know, he is a new entry to my recently republished 5th edition, my Encyclopedia of Constitutional Amendments. He's actually
Excellent.
the first entry there because he has a lot of, long before this border incident, there are a lot of, he's advocating a lot of changes in the U.S. Constitution. And by the way, the Republican Party in the state of Texas had actually proposed, and I don't know if they went forward with it, they were actually going to have a referendum as to whether Texas should stay in the Union or declare itself an independent republic.
Was that recently?
Yeah, I mean, it was scheduled.
How did I miss that?
I think it was scheduled for like 21 or 22, and I don't know if they actually had a vote or not. You know, and it would it would not have been. But what's fascinating about that is Abbott is using a clause out of Article 1, Section 10 of the Constitution, which actually consists of limits on state powers.
And Article 1 deals with Congress. That's the legislative
powers. Article 1.8 are the powers of Congress. Article 1.9 are limits on the powers of Congress. Article 1.10 are limits on the states. And Article 110 prohibits prohibits states from making war unless they are actually invaded. And
interesting.
This clearly was done at a time where, you know, national armies were not that great. And if you were a southern state and you were actually invaded by Mexico, or northern state by Canada or whatever, you'd be able to react quickly. So
of course,
Abbott is calling immigration an invasion and is saying, well, we have the right to do what we want. Well, of course, Article 6 of the Constitution says that the U.S. Constitution, laws and treaties adopted thereunder are the supreme law of the land.
The supremacy clause.
We've been through this before. In the 1820s, John C. Calhoun of South Carolina advanced the doctrine of nullification, that if states didn't like a law, they could simply adopt their own law. So essentially what's happened is Texas has adopted a law which says we're going to arrest any illegal aliens and I'm using their terminology,
right?
Any undocumented folks, and we're going to, try them and deport them. This is a federal power. Article 1, Section 8, powers of Congress. Now it's not quite as clear as I'd like it to be, but Article 1.8 gives the powers of naturalization to the national government,
which in definition is essentially immigration. They get to decide who becomes a citizen. Well, it's as close to
immigration as we have there. Yeah, the only power. It's sort of interesting. The only power that I know that the states had over immigration, and some will react to the term, but I'm just trying to get as close as I can, was the 1808 clause, which said that states could continue to import slaves. They didn't use the term, but such other persons for the next 20 years. And that I think Congress could tax up to $10 a person or something like that. But essentially,
even then we've got, all of our laws are based on federal agencies dealing with immigration.
Sure.
Whether it's legal, illegal, however it is, we've got ICE. However many people don't like ICE, that is a federal agency.
Well, and this works both ways, by the way. And I'm not familiar enough really to discuss intelligently the so-called sanctuary cities.
Right.
But to the extent that a sanctuary city is saying we're not going to, well, I guess there's a difference between saying we're not going to enforce federal laws, we're going to leave that up to federal agents, and saying we're going to defy federal laws.
Correct.
But essentially, there was a case last week, in which Abbott put barbed wire over some of the walls or entrances to Texas and the court has said the wire has to come down.
But which court has said that?
U.S. Supreme Court.
Okay.
And
so the highest court in the land has said you can't do that.
I mean, we've been through nullification and secession and Civil War, and most of us think that that issue was pretty much resolved. But it does cut both ways. I mean, it could be that in the future it will not be a conservative governor in Texas, but it'll be a liberal governor in California or Minnesota or somewhere else who will similarly be defiant. But if we had a confederal system where essentially states were sovereign,
right?
And I mean, more recently, do you want another George Wallace standing in front of the door of a university saying segregation now, forever?
Right.
No, we have a national policy, and the national policy may be very flawed. And ironically, to pick up on our conversation last week, it appears as though what we feared is actually happening, because Congress seems close to a compromise on Ukraine, Israel, and the southern border.
Sure.
And Donald Trump is saying, no, what many people think is happening, he's saying, no, I want to do that under my presidency. I want it to continue to be a problem here under Joe Biden so that I can benefit from it. So, whose interest are we going to put first? Is it, if we really have a crisis and people believe it's a crisis, take care of it now.
Right.
And if you can't get 100% and you expect to be reelected, as Trump does, then when you're reelected, you can add to it.
Right.
But if we have an immediate problem, that problem takes priority over the election of either Biden or Trump.
You shouldn't push it down the road. It's still an emergent problem.
Exactly. I mean, it's a really disturbing phenomenon.
So let me ask you this. As the constitutional law expert and the Constitution expert, we've got this Supreme Court decision that now says you cannot do this.
Right.
We've got the governor who is still ordering the state to put up the barbed wire. Right. What happens now?
It's a great question. Well, I mean, you could do what President Eisenhower did in 1958. You could send National Guardsmen in and physically enforce it. My guess would be you would first, I don't know, sue the governor or sue the state. Maybe, with some penalty short of execution, that might still get their attention.
Right. But does it have to go back up to the Supreme Court? I mean, they've already made the decision.
Well, I don't think it would have to go that far. I mean, I think if you had a case, an enforcement case in the lower court, those courts would feel themselves bound by what the U.S. Supreme Court had said.
And then we get back to the president, so the third body of government. So the president has the requirement to enforce the law.
That's right.
So that's how he would be able to call out the National Guard, saying we've got the interpretation of the law.
Right. Again, it's the sad thing is, and I'm not sure that the facts are completely established.
Sure.
But the sad thing is, a week ago, a mother and two children drowned crossing the Rio Grande, and federal officials claim that if they had been there, they could have saved their lives.
Right.
No political issue is worth that, even if you think the mother is guilty for bringing her kids here, the kids are not criminals.
Right.
And posturing sounds fine. It gets you votes, but when it affects the lives of literally life and death situations, people need to back off a little bit.
Yeah.
A little Christian charity would help you.
Assuming it's the actual practice of true Christianity as taught in the Bible
any
versus
kind of charity. I mean, it doesn't
right.
even have to be, you don't have to be a Christian to believe that innocent people should should not be allowed to die if you have it in your capability to stop it.
Right. Okay, so that's Texas. Yeah. Let's head to the 8th Amendment with cruel and unusual punishment and talk about the momentous execution of the week. Tell us a little bit about what's happening.
Well, Smith, a gentleman whose last name is Smith, about 2 years ago, they went to give him a lethal injection, and they couldn't find a vein. They worked very hard to do it, but they couldn't get it inserted in the time that they had to do it under the law. And so they've decided that, maybe lethal injection doesn't work very well with them. I think they're also having trouble getting the ingredients. So they said, well, nitrogen, if you just breathe nitrogen, that might kill you too. So let's try it out. Now, there's a strong resemblance between this case and a 1947 case, which I'm sure you remember from constitutional law.
Of course.
Louisiana versus Resweiler.
Of course, that one.
They had a mobile, Louisiana had a mobile electric chair, which they would carry around to execute people, and they plugged Francis in, and nothing happened. And then they came back and said, well, we want to execute him. That didn't work. We want to do it again. And the Supreme Court said, well, it was a split court. And it said, well, it wasn't anybody, what the state didn't purposely do this. So it's not cruel and unusual to execute him again. I always thought that decision was wrong. I just don't think, if God intervenes or nature intervenes,
you should get
give the guy a break,
reprieve.
keep him in prison the rest of his life. But this is sort of similar. I mean, it's a second execution, which means that which means he's already gone through the agony. Now, he's no Sunday school teacher.
Sure.
He was a hired killer. And speaking of Sunday school teachers, he was hired by a preacher to kill his wife, which he did. So, I mean, it's a heinous crime.
Oh, my goodness.
No doubt about that. But I think my focus, if this had come to me on the Supreme Court, and the Supreme Court basically denied a stay of execution, and most of the time they do just deny this.
So there wasn't an official opinion?
Well,
or was
there? There were actually 3 or 4 justices who said they would have taken it. So, but it was not a full written opinion. But I think I would have said yes, a stay is required, because if anything, we don't, and there's now debate as to whether it was cruel. The state says he held his breath and tried to struggle, and that's what it calls it. The preacher observer says the guy was twitching for 2 minutes and then another 2 or 3 minutes of agony, and this could have been avoided. But whether it was cruel or not, it was clearly unusual. We have never executed someone in the United States before through nitrogen, and as far as I can tell, I don't think they did this with rats or mice or monkeys or
no other experiments.
I mean, and again, I'm not an expert on it, but it's, it goes back in 1973, Furman versus Georgia. The Supreme Court decided that as then administered, the death penalty was unconstitutional because, and then subsequently they said, well, it's not unconstitutional in and of itself. It's only unconstitutional if you don't consider mitigating, you don't consider aggravating factors, you don't do it by a jury trial and the like. But what's also disturbing about this case is my understanding is the jury decided to give this man life in prison, and it was a judge who said, no, he deserves the death penalty. And
so he overrode the mercy of the jury.
He did, and there may have been warrant for that, but that seems inconsistent with the standards as I understand them that the court has imposed on death penalty cases.
Interesting. But despite all of that, he was officially executed this week.
He was, yes. And in fact, what was fascinating, the the person in the room with him, the spiritual counselor, had to sign a statement. They had never done this before, and they were not sure what the impact might be on an observer. So he had to sign a waiver saying, yes, he understood that he could die from this as well.
Wow.
Which is a pretty gutsy chaplain, I would say.
Absolutely. Wow. Well, and in my understanding, there are so few states right now who actually either have the death penalty or even impose the death penalty.
Well, Texas is big on the death penalty. Southern states generally, and again, there are different cultures within the United States. That's what federalism is about. And so you do have, I don't know if Alabama is a particularly high. Texas is the one that usually stands out as doing a lot of them. But if I recall, the Biden administration are actually pursuing a death penalty in the case of the Buffalo shooter. I believe that's the case. But for the first time in his administration, they have actually pursued a case involving a capital punishment.
Federally.
Yes.
Yeah, I was on, as a prosecutor in Newport News, Virginia, I was on the motions team for a capital case, and it was the first one they'd had in like 12 or 16 years. This was back in 2013, 2014. And I remember the office's idea was, well, if this case doesn't get the death penalty, then no case gets the death penalty because it was so awful. And sure enough, the jury found him guilty of the capital case of capital murder, but they did not impose the death penalty.
You know, one of the fascinating things about this case is Smith was white, and as far as and I believe the murder was of a white person. And you know, one of the major concerns about the death penalty is it is most frequently given to African Americans, and particularly African Americans who kill whites rather than fellow African Americans. And so that was not a particular factor in this case. Now, race has come to factor in a very fascinating development in the Fani Willis case.
Let's talk about that.
Okay, it's sort of an odd jump here.
But it's still the hottest legal topic.
Right. One of the defendants has charged that Willis has hired a prosecutor, paid him an inordinate amount, and that they have a romantic relationship in which he has gifted her with vacation trips, presumably from the money that he's making as a prosecutor.
So a conflicts of interest claim.
Right. But what's the little wrinkle that we got this week is that Willis appeared in a church, which she has every right to do, obviously. But she was given the platform, and she argued that the reason they were coming after her and this other attorney was because of their race. You know, wasn't it interesting that they went after the two blacks rather than the other white prosecutors?
Oh, sure.
And Trump is now saying, well, you know, prosecutor has no business, you know, this is tainting the jury pool. Now, I think what would happen there is even if it was decided that her words were racially inflammatory, I think that this is something that you would take care of by voir dire.
I believe so too.
Think you would give some more, which is the process of selecting jurors. And, you know, what's fascinating about this, you know, the prosecutor, in a sense, it doesn't affect one way or the other whether the people she's charged are or are not guilty of racketeering.
Correct.
And in fact, some of them have already pled guilty to this.
Right. And
including Sidney Powell.
The thing to me that separates it is whatever her motivation, and I'm not giving her a pass.
Right. No.
But it was brought before a neutral grand jury. And a grand
juries are notorious.
Rubber stamp.
They say a good prosecutor can indict a ham sandwich.
Of course,
but it's caution there.
Still, technically, in the justice system, they are pulled from the general community
Well, and it will then have to go to a petit jury, which would decide on guilt or innocence.
So it's a separate piece that they have said, okay, there's probable cause. So it's not like she just went after them. There's a separate body for good or for ill that has said there's probable cause. And to me, there's no reason not to have the petit jury, the trial jury, then decide if there's enough evidence. Now, maybe she should be taken off the case. Maybe another prosecutor presenting the evidence. It smells
maybe
bad.
Two will need, her misdeeds do not necessarily void the indictment or future prosecution. But if she, in fact, engaged in a romantic relationship with somebody that she's hired and paid a lot of money to, that certainly seems to be very indiscreet on her part.
Absolutely.
It would certainly raise question. I would not want to be prosecuted by someone who I thought was making inordinate money or was in some kind of romantic relationship.
And it's certainly something that could be brought in the ethics bar. That she could be brought up against in the bar of her state saying this is unethical behavior by an attorney. She should be censured. She should have her license revoked. That seems to be the appropriate arena. So it sounds like if there's credibility to it, there absolutely should be some kind of, I hate to use the word punishment, but some form of issue for it, something to be done for it.
It should not be allowed to affect the prosecution.
Right. Let those charges stand. Let that is guilt versus ethics.
Well, it's not guilt.
Well, guilt versus...
It's predicate to guilt.
The idea, that the jury would be finding whether they're guilty or not. It doesn't make the defendant's actions not guilty. It doesn't mean that they're not guilty of a crime just because she might be unethical or behaviors might be unethical. So to me, it's two separate things, but it doesn't look good.
No, it doesn't. And it sort of feeds into Trump's narrative that, this is all political. People are out to get me. And I mean, this is not just Trump, but, a lot of other
for their own personal gain. So they're saying, well, he's doing it for personal gain. Well, this certainly seems like someone's doing it for their personal gain against him.
Right. Yeah, I mean, yeah.
Okay, so now let's go to Trump, and then let's finish on Michigan. Which one? No, the international court, because we got to get Thomas Hobbs in there.
Yeah, we sure do. I mean, so what? I mean, it's fascinating. There's been a case brought against Israel in the International Court of Justice, basically saying it's engaged in genocide.
Right.
And it's a very bizarre argument when you think about, this was predicated by an attack by a group that has said they want to wipe out all the all the Jews.
Right.
But what's fascinating about it is the court, as I understand it, has said there's enough evidence to go forward with a trial on this, and they have strongly encouraged Israel to cease its operations or at least its method of operation in Gaza.
Right.
But what's fascinating about the internet now, Israel, I understand, is a party to the International Court of Justice, but we're similar to, only this is a magnified example of Texas, and what are we going to do about a governor's defiance?
Right.
Thomas Hobbes posited, that in a state of nature, if you had no laws that were established, settled, and known, that there would be a war of all against all. And Locke and Hobbes both said, the problem with the state of nature is even if there's a sense of morality, you don't have an impartial judge and you don't have an impartial enforcer. And this is what happens in international law. I mean, we can scream, as I have many times, about what I think the outrage of Russia invading Ukraine is. But there's no outside force other than Ukraine itself or its allies.
Right.
Who are going, you can tell Russia you're doing wrong, and Putin is going to go ahead and proceed doing what he's doing. And so it's sort of a reminder, that international affairs comes much closer usually to the state of nature than do internal affairs. Although, if you look at a country like Haiti, or if you look at what's happening in Bolivia right now and other nations, sometimes law breaks down, and you do end up back in a state of nature where the biggest gang or the biggest gun or the person with the greatest force or group with the greatest force ends up terrorizing everyone else.
And I mean, look at the International Tribunal for the war crimes with Rwanda.
Right.
I mean, that to me is one of the most shocking examples in the last decades.
Yeah. Yeah, and again, in some, in South, I guess it was South Africa, wasn't it, where they had Truth and Reconciliation Commission, where essentially they agreed that they would not, I don't know if it was no punishment or no execution, but for those who at least would tell what their role was, you could at least get it out so people would understand the magnitude of the crimes that had been committed.
Okay, so now let's touch on the E. Jean Carroll case. It was not as exciting as I thought it would be this week, I gotta say.
No, it wasn't, and particularly after the New Hampshire primary.
Right.
How you can win a primary and then start spitting nails about how angry you are. But
it was
maybe
a huge
it was
success for him this week.
Pardon?
Huge success for Trump this
week. Well, it was a success. I don't know if I call it a huge success because, Haley got 40-some% of the vote. It was like
a larger percent than expected, but maybe because
certainly than was
dropped out
earlier expected. But yeah, you would think the best thing to do is to emphasize, and he did, after Iowa, he really sort of emphasized the positive.
Right.
After New Hampshire, he just seemed perturbed that there was still somebody in the ring, in the ring with him. And I was thinking, okay, he's going to go to the trial the next day and be so upset. And of course, they postponed the trial for a day.
Right.
And the judge was not broking any nonsense. He basically grilled the attorney, now what is your client going to say, on this? And Trump ended up adding a sentence or two after the yes or no. The problem, of course, is there's already been a trial that has ascertained that Trump is guilty of an offense.
Well, he's liable for defamation.
Right. That's right. It's civil rather than a criminal case. And what happened is my understanding is after that verdict, he has continued saying the same things.
Correct.
And he's been sued again for defamation. And, here's one where, the law is supposed to be equal. It's not supposed to discriminate against you because you're poor or because you're rich.
Right.
But this is a case where being rich doesn't help.
Right.
Because once you get beyond, what are the compensatory damages? How much did you actually damage this woman's reputation? Then you get to punitive damages. How much do you have to charge to keep somebody from doing this again?
To keep them silent.
If you're a billionaire, you might have to charge them a lot more. I think they're now asking for $30 million than you would if you were not.
Right.
And by the way, this goes to another legal issue, which I'm sure
bring it on up.
Maybe no one has ever discussed on this forum before, but there are people who suggest that parking and moving violation tickets ought to be based on wealth. If I'm a billionaire, I just speed all the time and pay the $100.
Right.
But if I have to pay the equivalent for my income or if I had to pay $100,000 every time I speed,
maybe I wouldn't.
Yeah, maybe I wouldn't. So it's just sort of an interesting, lagniappe, as we would say, as Louisianians would say, a little extra here.
Yeah, so
spice on the side.
Right. And so the spicy with the testimony, it was like 3 minutes. I was so excited. And I was like, wait, you blinked and it was over. Where there were 3 questions where Haba asked whether he stood by his testimony in a previous deposition, denying her allegations. He says 100% yes. She then asked, did you deny the allegation because Ms. Carroll made an accusation? And here's where he says, that's exactly right. Yes, I did. She said something that I considered a false accusation, totally false. This is when the judge cut him off, saying the court has to strike what he just said, completely disregard it. And this was the fear going in, because he was instructed throughout the trial, his counsel and him could not claim that this was false. Right. Because there was already a decision that it was defamation. So he was told continuously, you cannot say that it wasn't defamation. You cannot say that you didn't sexually assault her.
There's actually a little wrinkle, though, as I understand it.
Okay.
The court didn't originally determine that she had been raped.
Correct. It was sexual abuse.
Right. And when he denies that and the judge says that's already been determined, well, there's at least a little difference in the terminology.
There is.
So it may not be completely over here.
Right. But the continuous, I mean, for all these weeks, the judge has said, you cannot say you didn't do this. No one can say you didn't do this. And that's the second thing out of his mouth is completely false. So,
well, and again, different audiences.
True.
Courtroom and the political arena.
But to me, the courtroom, this is where I would have cried foul and said, look, you know, how many times do we have to tell him this is a mistrial? Because how can the jury mishear this? How can they pretend they didn't hear it?
Well, and we found this in mock trial, right? Mm-hmm. Strike that from the record.
You can't unhear
Striking it from the record and striking it from what somebody has heard may be two different things.
They've already heard it, and they've heard it from the former president. So how much weight are they going to give it? And to me, it strikes of complete defiance. Of he's going to get up there and say what he wants to say in order to improperly influence the jury. So in my mind, if I'm Jack Smith, if I'm Fani Willis and I'm looking at this, I am going to pin down any testimony he might have before he gets on the stand. With as many,
to do that.
They did, but it still didn't work. So how do you control
by the way,
it?
My understanding is midnight or last night, he got on the media and repeated the charges pretty much.
Right.
So here's where it becomes a little precious that he's using social media to influence the audience.
Right.
And his folks are accusing Fani Willis of using her platform to, not necessarily consistent.
Right. Yeah. So the final question was, did you ever instruct anyone to hurt Miss Carroll in your statements? And he said, no, I just wanted to defend myself, my family, and frankly, the presidency. And that was about it. So he gets off.
And that was struck as well. Everything after no.
Yeah. So I think today, this is Friday, we're hearing closing arguments. By the time this is posted, we may even have a verdict.
We might.
But stay tuned. We'll address it next week. Hey, everybody, quick intermission. This is just Virginia. So since we were doing the taping, we were talking about the E. Jean Carroll trial, and the jury had not yet come back. We are now publishing the case, or publishing this episode, on Monday so that we can include the jury verdict. It was shocking. The last verdict last year for the original E. Jean Carroll trial was about $5 million or 10. I can't remember exactly which, but Trump had to put up that money in bond, so to speak, in escrow with the court in order to appeal. This is normal for civil cases where the court requires the money to be put up front so that if there's an appeal and if the plaintiff still wins, that money is available to the plaintiff. In this case, that's exactly what's going to happen. It's an $83.3 million verdict in favor of E. Jean Carroll and against Trump. In order to appeal in the New York court, he is going to have to put up at least some kind of money. Normally, it's 100%, so the $83.3 million, but it's also usually extra costs and expenses. The transcript has to be paid for the reporting costs. There's a court reporter that makes a transcript for all of the days of trial. That has to be paid for. Usually the court costs have to be fronted and put into escrow. It is possible that bond would be taken rather than a full cash amount. So that would include at least some cash amount as well as collateral. This is some kind of property that's put up. In $83.3 million, it's not your normal house that's put up. This may require Trump to actually put up one of his larger properties. I don't know about the Scotland property. I'm not sure it would even be used as collateral since it's an entire another country that's at play. And usually there's no property that can be tagged. So the property that is normally tagged and put up for collateral is in the same state as the judgment. So in this case, $83.3 million is the verdict. Most of that was punitive damages. And I pulled something up to make sure I'm saying it right. $18.3 million is compensatory, so a replacement for the reputation that she lost. There's no real quantity that can say, well, it's, like a medical expense. But in this case, the jury said, you know what, the loss of reputation was so bad, we're going to award $18.3 million just for compensatory, and then we're going to add $65 million in punitive damages. As we're talking about through this episode already, the punitive damages are what the jury says, you know what, this is what it's going to cost because it's so bad and done so many times that the only way we feel that we can prevent it from happening again, this is more of a punishment verdict in the civil world, is to give an amount for punitive damages where we hope that that will stop the behavior. Now, there's claims allegedly that Trump has already appealed. I'm not sure how that looks for the appeals bond and escrow. So in the escrow, he's already got the last year's verdict so that if he is ruled against, it can go to E. Jean Carroll. Something similar is going to have to happen. Now, in most courts, it's not just that amount. It's usually, like I said, the court cost, the reporter's cost, and sometimes up to 110% of the cost so that anything extra is covered. So that's where we stand with E. Jean Carroll. It is a shocking award, even for me in the civil arena, especially for the punitive damages, and we'll see what happens next. Let's hit the final topic, which might be the most contentious for us, of the Michigan shooting. The boy who shot up, I think it was the elementary school.
I believe it was junior high or high, but
that's right. Uvalde was the elementary school.
Yeah, Oxford High School. Yeah, in Michigan.
And his parents have been charged. This has been an ongoing thing several years now, but his parents were charged, and they have been charged with involuntary manslaughter.
Right.
Now,
and they're being tried separately.
Yes. Tell us how this is set up and tell us a little bit about the law in Michigan, because I know that you've got a little bit more of those details.
Well, I'm not sure that I have stronger opinions maybe than you do without having much more knowledge. But my understanding is she is being charged. The mother's on trial first.
Right.
And between the two of them, one of them bought the weapon. The mother is actually seen taking him to a shooting range, which you might say was actually responsible.
I've taken my son to the shooting range.
Yeah, I mean, if you're going to give someone a gun, then you need. But she's being charged, as I understand it, with involuntary manslaughter. And if you were to ask me, with what I know, which is limited, was she a responsible parent? I think the answer would be no. Was she grossly negligent? I think the answer would be depend on the facts. Right. Which parent is more responsible? What did they know and what didn't they know? But
yes.
I think you could make a good argument. I think if your son or daughter had been shot, or you were the teacher who got shot and survived, I think you could bring a case against the family for damages. But I'm concerned that apparently no one has ever before been charged in a case like this with manslaughter, which is a criminal offense. Mm-hmm. And to me,
because of the actions of another of their son.
Right, because of the actions of another person when they were not on, well, Now let's
I mean,
think
there's the
about it.
hitman theory, but that's different.
Yeah. Well, I mean, you have the Manson case. Manson was not in California. He was not on the scene when this massacre of.
But there was the conspiracy, where in this case, there's not an alleged conspiracy among the parents and the son.
I'm concerned that this resembles. Now, I'm not sure that this would be the technical answer, but the Constitution prohibits ex post facto laws, and they are laws that either make something criminal today that wasn't yesterday and charge you for it, or aggravate a penalty that wasn't in place. You know, when you committed a crime, there was no capital punishment, and they add capital punishment afterward and try to impose it on you. And I'm concerned that if, in fact, this is the first such prosecution, that a person did not have due warning, and so would be a kind of ex post facto. Now, I understand you have a different view of this.
I do. I have, so I'm looking it up here because I want to make sure I get this. So
you're going to pull a case out on me that I don't know. Go ahead.
No, I've got, well, possibly. So I also, you said you might have more passion on this one. I don't know. I might have equal, if not more. So in Michigan, it says any person who shall commit the crime of manslaughter shall be guilty of a felony. But I want to make sure that we get what are the elements of manslaughter? What do you have to prove? So it's killing of another without intent. Okay. It is... Goodness. So killing of another without intent, but usually it is... okay, so without intent, malice, or premeditation. They created a situation where the risk of great bodily harm or death was high, knowing that as a result of their actions, he or she, that they knew at the time that serious harm or death would likely result. So in my mind, this is not ex post facto, where someone could look at this and say, okay, if we look at, and I don't know all of the facts, this is what would come out in trial, but based on what they knew of their son, based on what they did with getting him a gun, teaching him to shoot a gun, I think the biggest issue is what they did that day. And I don't know all the facts, but if I recall correctly, it was something to the effect of they had reason to believe that he was bringing a gun to the school. They had some kind of text communications where they had reason to believe that he was about to shoot up the school. One of the parents made a comment to the effect of go get them, or I mean, it was something glib where they either really didn't realize this is what's going on and it seemed like they were joking, or they did and it was seen as an encouragement.
And to clarify my own position, if they withheld information from the school about the possession of a gun, I don't know what offense that would be, but I suspect that that might be an offense.
And that's why I think they're charging the involuntary manslaughter, where if they had knowledge that there was a risk of great bodily harm or injury or death, that they could be guilty of involuntary manslaughter without them having done it. It's a lot like negligent homicide, right? Where if you get into a car, you've been drinking and driving, you don't go out and purposely try to kill somebody in a hit and run or a drunk driving incident. But your actions have created such a high risk of the possibility of death that, you know, if it happens, then you should have known. It's a newer should have known standard. And in this case, okay, look, let me say this. It terrifies me as a parent that I could be held guilty for an action of my child. Terrifies me. I cannot imagine if my children went out and committed such a heinous crime that I would then be picked up and put in jail. Now, there's an ignorance issue, though. And the question in my mind here is I don't believe it's improper to charge them. I don't know that they will be convicted, and I think there's a lot of sympathy there. I even have sympathy for them. Did they really understand?
You don't want to think that of your own children.
No, and most parents don't, right? There's like, well, he wouldn't do that. Maybe he's joking.
And let me add something else, because this often comes in, and it bothers me that so many times will associate a school shooting, and we had one in Nashville recently that
At the church
seems
school,
to be the
yeah.
Covenant School, seems to be tied to some kind of mental illness.
Right.
But most people with mental illnesses do not act out by killing people.
Right.
And so even if you knew your son
Had mental illness.
or child had mental issues, you would not necessarily now. Would it be one? You can go to actually in Plato when Socrates discusses justice. One of the questions is, well, if justice is giving people what they deserve, if somebody owns a sword and they're insane, should you give it back to them?
Right.
And the obvious answer would be, well, no, not while they're insane. You're not doing them any favor.
Right.
So but I don't. I mean, maybe the good thing about this is maybe. I think it's going to a jury. Maybe a jury trial will clarify the degree to which the popular mind would say, yes, this is guilt, guilt enough to go around to 3 people, or let's focus on the person who actually did it.
Right.
And again, absent intent.
Correct.
If the parents had if they wanted the school shot up, then put them in the same category with the son.
Absolutely. Put them in with first-degree murder versus the involuntary. And that's where it's the difference is they're not saying this was their intent. They're saying clearly it's not their intent. But it was such a reckless disregard. So how much can they prove that they actually knew? And that's what the facts are going to turn on. So I don't think it's improper that they're being charged or they're being tried for it. I think it is literally a factual decision of a proof of intent. How much can they prove? So like
Macau, you could argue this on either side, couldn't you?
You could. And now
And you would do due diligence to either side that hired you. I mean, you would
absolutely
have the responsibility. Yes,
absolutely. And so let me compare it to 2 other cases. So let me do it to the most closely resembling in my mind, and then wrap it up with another. Is the Newport News shooting? The Newport News, Virginia shooting with this 6-year-old last year who shot his teacher, who survived, had multiple surgeries, has had traumatic effect and permanent injuries, but survived. And so that one has been close to my heart because I prosecuted in Newport News and know the jurisdiction, know the laws fairly well. The mother of the 6-year-old was charged with multiple crimes. She was charged with multiple crimes in federal court and in state court. So in Newport News, the city of Newport News under state jurisdiction and the federal court in the same jurisdiction. So in the state case, she was charged with child neglect, criminal child neglect. By her action, she actually was neglecting her own child and putting him at risk.
Well, and in fairness to her, I think he was a very troubled child.
Yes, that appears to be.
It's probably hard for any parent to constantly keep track of everything there.
Right. But then she was also charged with federal cases. But it wasn't manslaughter. It wasn't attempted manslaughter.
Right.
It wasn't attempted any kind of murder or harm. The federal charges were interesting because she was charged not with the actual issue with the teacher. She was charged with using marijuana while in possession of a firearm, which was a felony, and making a false statement about her drug use during the purchase of the firearm, which is also a federal felony, where you can only get a firearm if you aren't using drugs.
Similar to one of the charges against Joe Biden's son, right?
Hunter Biden.
Yeah.
Exactly, is he should not have been able to get a gun because he was actively using drugs.
Right.
So in that case, it's interesting because, I mean, it's a 6-year-old versus a teenager and an adult, but she was not charged with any kind of attempted wounding, attempted malicious wounding, attempted murder, actual murder. She was charged with the child aspect and with the firearm aspect.
Right.
So I think that's a really interesting contrast between the two, where something heinous and horrible has happened by a child that is yours. And what's the difference in the charges and how they go? So
it would be interesting, wouldn't it, to know whether the prosecutors weighed, were there some other charges that they could have brought.
Oh,
In
I
my
know they
judgment,
did.
they would have had a better chance of winning on those. On the other hand, I mean, maybe it's time to set a precedent. Although, I mean, I don't know. It seems like we really just don't want to tackle the issue of gun control.
It's hard.
And you know, and so we sort of look for scapegoats. You know, it's the insane, it's the parents of the, you know, the mentally ill, it's this and that, rather than, well, you know, maybe it's the caliber of the weapon that we let, you know, maybe it's the
the
maybe
type of weapon.
Now, you know, should the child have ever been able to have that kind of weapon at that age?
No.
You know, there are all kinds of questions.
No, the access.
As a society, we really haven't addressed very well.
Right. So the final application that I have, these ex post facto laws, et cetera, is I was in Virginia prosecuting when we were using for the first time, whether you agree with it or not, it appeared to be a matter of first impression while I was there that we were prosecuting distributors of drugs for felony murder, where if they distributed drugs and someone overdosed and died, that they would no longer just be convicted or prosecuted for possession of drugs or distribution of drugs, but that could then extend to felony murder, which would be death during the commission of a felony. And I was there
I'm assuming
through
this
that.
is not marijuana we're talking about, right?
No. Oh, no.
We're
It was
probably talking about psychedelic drugs or
Schedule 1 and 2.
That would,
heroin, cocaine, meth, that sort of thing. And it was an issue of first impression, as it hadn't been tried before. And I did presentations on how far does the felony murder statute go? Can it be applied to this situation? And since then, it has continued to be applied. But I was on the first in Winchester, Virginia. I was the one who did the first prosecutions for those. Now, again, I haven't been prosecuting felony murders for that for a very long time, but to me, just because it's been done for the first time doesn't mean that is an ex post facto law or shouldn't be done.
I acknowledge that, and I said it's like an ex post facto law, but I don't know. We've had so many shootings that if this is many of them by young people in high schools. And if this is the first application, I would be wary of it.
And truly, as a parent, it terrifies me that I don't like it. I hope it doesn't go through for the sake of everyone, all of the parents who are trying to prevent a school shooting, who are trying to get their children help. The mental health system, in my mind, is broken. It's not in a place where it effectively helps and treats especially children. And the idea that even if I know a child has mental illness, I can't prevent it, but I would be charged, truly is frightening. And I think to many other parents as well, because how many times does this happen now? And the parents are asked, well, did you know? Were there any signs? Why didn't you do something?
With drugs, I mean, there are certain types of drugs, particularly fentanyl right now. I mean, it's gotten worse since you were a prosecutor.
Yeah.
Or I would assume, if you're knowingly distributing fentanyl, we know there's a pretty good chance somebody's going to die from
substantial risk.
And a case like that, I think I would agree that if somebody does die, go after the distributor.
Right.
Though what would probably happen, it would be not the distributor, it would be someone on the street,
right?
Doing a side hustle who probably had no idea that he was selling fentanyl.
Right. And that's the other thing is it was the sad part about those, that, first of all, clearly that someone had died. But the other part, it was usually a friend who was sharing their drugs. It's like, oh, they're at a party. Well, here, have some of mine. Didn't realize how much they had been giving or that it was laced with the fentanyl. And they end up dying and they drop the guy off at the hospital or they run away and nobody reports it because they've given them the drugs. So there are some amnesty rules throughout the states where if they actually report it, they may be saved at least from the felony murder prosecution, but not necessarily the distribution or the possession.
It's unintended consequences of laws.
Yeah.
Always something to be wary of.
Okay, so I think we had some lively discussions as promised at the beginning.
We did. Yeah.
If anybody likes the discussions we're having, please click like and subscribe to the YouTube channel. Make a comment. I am catching up on comments. So anyone who has made a comment, bless you. I love them. I'm watching them. I am trying to respond. That's true. Most of them I do. If they're offensive or just mean or cursing, I really don't love them. It's disrespectful. But most of you out there are having really good conversation topics. And I am getting to them, I promise. So stay tuned with us. Continue to like and subscribe so that you can see next week's and the following, as well as to get it out there to more people who can see us and keep up with the hottest legal topics of the week. I'm Virginia Tehrani. I'm with Tehrani Law, LLC. This is Dr. Vile with Middle Tennessee State University, and we will catch you next time on The Law Unscripted with the Legal Weekly Wine.